set that up now. Let's go. Right, we are live, streamed, and we will have under the Logitech webcam properties. Pick this one here. No, just didn't like that at all. No, just didn't like it. Just doesn't like that USB. I'll bring it up here as well. Sorry, I've got a picture of a cat because I can't get the. Probably would work if I swapped them over actually. I'll swap it to there. See how we go. Nope, still didn't like it. Okay. So this, I guess this seminar is really more, it's a more comprehensive explanation of what, not so much law in general, but, oh sorry, I'm all gross, yeah, said I haven't been very well. Law in general, but also the Australian legal system in particular. How the structures got to be the way they are, how the various court systems work and function in relation to each other. And this is the stuff where, in the general sense, forms part of your assessment, because we're talking about the court system and how things work from a very practical level. Even though this is a level 9 subject, you guys are expected to, to really know and understand the material to quite an in-depth level. There is very much this expectation that you're self-directed. And so you'll find that a lot of the tasks in this piece of assessment are actually going out into the world and finding out how these particular structures work. In terms of courts, for example, it says things like go and find out what things like application fees, what are the time lengths, which court do we have to go to. Why am I getting that? Oh, sorry. Should turn that off. Okay, that must be an odd one. And so that's why I think it's a useful and a practical step. And the other really important thing that we do from this stuff is to talk about statutory interpretation. Now, again, we don't have the same expectation on the business students, even at the MBA level, to be able to do and have the graduate attribute of being able to comprehensively read statutes and to go through and use and understand all of the statutory interpretation rules. But at the most basic level, you guys do have to go and be able to read statutes. You physically go and read them and really understand the internal logic that goes with statutory interpretation. Really, that's the key component. So again, some of the stuff I'm going to go over is stuff that I talked about broadly last week and touched upon. And those things are to do with the Australian legal system. And I mean, obviously, the examples I'm going to use are generally going to relate to Queensland. But the systems that got to be where they are now have come from somewhere. It's one of the more difficult aspects of law as a discipline is that you're dealing with a lot of history. I mean, if we think about all the various disciplines in other areas we've engaged with over the years, and my partner was a geologist, and so that's a discipline that really only took off in the 20th century. And other aspects of science as well, if you think about it. A lot of things, botany or microbiology, nuclear physics. That's something which has only existed in the 20th century, whereas law, in the broader sense, has been around for 10,000 years in the very sort of basic sense of the way humans operate with structures between themselves. But I'll go and talk about the history of the Australian legal system and how that came about. And some of these things, it's not, strictly speaking, it may not be of huge worldly use, functional use to you guys, but you find that with a lot of these things, answering and understanding the question of why these systems exist, how they came to be, can really be, it can be helpful to start from first principles. It's like when I do physics at high school. When you start with the very basic principles, when you go through Newton's laws, and then you go and derive all sorts of other equations from them, kinematic equations and so on. Then you can sort of get the sense of how these things are fitted together. And you need to do that before moving on to the more advanced level, learning quantum theory and things like that later on. Okay, and so that's what the plan is for today. And I said I'll also go at the end after we finish the substantive merit from this. There's not that many slides. There's about 20 slides today, so I'm going to talk about that. But I'll also talk about this piece of assessment itself, and the one that you guys have already been given from last week. Okay, so we'll start with a case. And the reason why this case comes up, it's Malvo in Queensland, and you'll find with the way that cases are written, usually they will have two parties, and in the Australian citation system, the two parties' names have a little V separating them. When reading the case aloud, if it is what we call a civil matter, so between two parties where one of them's not the queen in a criminal matter, we use the word and. So this one is Malvo and Queensland, number 2. If it's a criminal matter and it starts with either the police or the Crown, which is a big capital R for Rex or for Regina, then we use the word against. So if it was R against, had capital R and then a little v, and then the party's name, Walker, it would be the Crown against Walker. That signifies a criminal matter. Malvo in Queensland is a civil matter that involved a constitutional matter. I don't know if you guys are aware of this. The guy, the plaintiff, now in civil matters, the party on the left of these things is the person bringing the action. They are known as the plaintiff. The person on the right, the party on the right, is usually called the respondent in a civil matter. In a criminal matter, the party on the left is usually the Crown or the police. The party on the right is called the defendant. You are defending an action against the state. But here, the plaintiff was a guy called Eddie Malvo, who was actually a gardener, groundskeeper at James Cook University. And so in the late 70s, Eddie Malvo was from the Torres Strait, and he worked at JCU as a groundskeeper, and he got to know two of the history lecturers here, a guy called Noel Luce and another guy called Henry Reynolds. They're still around in various sectors. I think Noel actually still lives in Townsville. And Henry still works, Noel as well, since retired. And they got to know each other and, would sit and have tea and biscuits or what have you together, and they would hear stories about Eddie talking about his ancestral land in the Torres Strait. And he said, basically the key thing that they took from that Reynolds and Luce took from that, when Eddie's Malvo saying, look, it's Malvo land, it's my family's land, it's always been my family's land. Right? The government's never come there. Everybody knows it. And they said, no, mate, no, you're wrong. All the land in Queensland belongs to the state of Queensland. And anything that the Queensland government's given away in terms of private use, that's fine. But everything inside is owned by the state of Queensland, and all other claims have been extinguished. And so this went, it actually went all the way to the High Court. This is a quote from the High Court decision. It's quite a famous decision in Australian legal history because a good fraction of the population in this room, in fact, possibly all of us, have come from places where the British have gone to. And it's a really important thing to note. Last week I talked about the Treaty of Westphalia and how in Europe, these nations that have been fighting each other 1,000 years, 1,000, 2,000 years, reached this point where, look, we're not going to stop fighting each other, but from this point forward, we're at least going to understand, or at least make a model for how we go about doing this. And so the key principles that came from that is that land could only be taken either by conquest. If you take land, if you conquer somebody, right, the default rule is their existing legal system stays the same until you change it, until you actually go about making change. Well, it seems like a pretty logical sort of step. The existing system stay in place until you go about changing it. All right. Other ways that things can happen are by succession or treaty. So we will exchange land, or there'll be some, often at the end of a war, they'll come to some treaty arrangement. This land that was ours is now yours. This land that's yours is now ours. And we will determine how the rules and the laws and so on that happen there are. But if there are people that already live there, again, until we effectively go and I guess manually come and change the laws of the people of that land, their existing culture, tradition, rules still apply. All right, so that's the doctrine of conquest, succession. And the third one is this idea of terra nullius. It's a Latin phrase that means land belonging to no one. So if you come to a place, Antarctica, for example, no one lives there. All right, if you go there, you plant your flag, you set people there, you have, build buildings, you demonstrate that you as a civilized people now exist in this place, that land's effectively yours. Sure, if the Dutch or the Spanish want to come along and conquer you, well, that's a discussion for another day. But until that point, the laws that you bring and put in there are the laws of the land. And so, again, I'm a New Zealander, and so quick recap on New Zealand history. I'm sure you guys love to hear this. New Zealand was populated about 1,000 years ago by explorers, navigators from Polynesia. So the New Zealand Māori people have lived since about 1100 AD. And when a guy called Abel Tasman, a Dutchman, was exploring in the mid-1600s, so the 17th century, and came there, sent some crew to the shore, and they got killed, and they went away again. And so they had these maps, but no one from Europe came back for literally 130 years, which is a really long time if you think about it. Hey, here's some land, a big bit of land, it's fertile. Okay, sure, it's in the middle of nowhere, but no one else came back to look for it. A guy called James Cook, an explorer who this university is named after, came into New Zealand on his second voyage and mapped. He was a very, very good cartographer. Mapped around the outside, and also kept notes about the people there in terms of their how their tribes were set up. He had a Hawaiian translator who was able to vaguely translate between him and the people there, a guy called Tapaya. And that was recorded in Cook's notes. And so then when they made it eventually all the way back to Britain, we're like, hey, here's land, there's some people there. And so people came to New Zealand, but it wasn't until some stage quite a bit later where there was a treaty. So New Zealand is an area where the British came, and the land was ceded, essentially sovereignty ceded, through a Treaty of Waitangi in the 6th of February 1840. And again, I'm not completely familiar with how the British got on in Kenya, I do know a bit about India, and I do know a bit about the partition, but the key thing to note there, and why this is really problematic in terms of the psyche of Indigenous Australians, and probably Australians more broadly, is that when the British came to Kenya, when they came to India, when they came to PNG, when they came to New Zealand, they recognised that there were people there. There are people there who have all the indicia of civilization, agriculture, laws, a hierarchy of rulership, technology. These things that you could recognise as the Europeans from the 18th century could recognise and understand and say, these are a people. They may not be for whatever level, maybe at different levels of technological advancement, but they're still a civilization. When the British came to Australia, they declared it a land terra nullius. So that means a land that's occupied by no one. And the reason for that, at least for a long time, was that the people, and there were people here, point out there were actually people here, but in terms of the British narrative, there was no expression or understanding or view that the people that were here had any of the indicia of civilization. Okay, and it's a really important point, not just in terms of the national psyche, but also in terms of law. Because one of the really important things about the British and what they call their common law system is that, again, when the British would go to places, and they would go to all sorts of places, there's actually not a lot of people in Britain. Have you guys ever realised or noticed this? Usually I do this big long spiel about the British. In fact, I'll do it when we come to the contract law part. But if you think about the fraction of people relative to a country like India, even going back 200 years, and the number of people in Britain. Britain's a tiny little island in Europe. There's not a lot of people there. The way that they would rule is often by using their mercantile powers, in other words, controlling the power of trade, to be able to play local leaders against each other. So I don't know if you guys, in terms of Indian history, how you read about that. And there's some quite horrible stories. A guy called Clive. I don't know whether you guys read about that in terms of your own history. But that's really the key mechanism there. And so part of doing that is that when the British come to an area, and the example I usually use is Jamaica, by the way, and the reason for that is Jamaica is, I don't know if you guys know, does anybody know much about the history of Jamaica? Jamaica was originally a Spanish indigenous people lived in Jamaica. The Spanish came along, and the British kicked them out in the 1600s and took it. But the key thing to note there is that when taking an area of land, the indigenous people's laws and customs and rules survive, and they actually get absorbed into the common law of that land. It's one of those things when we talk about all of these rules, and I talk about the way the British legal system works, appreciate that the rules and systems that happened in each country were in many ways merged with the countries that they're in. And so you'll see this idea of having essentially a superstructure that would fit over the top of existing legal systems. And so this would come up, and the main area that this comes up, and certainly in New Zealand and here these days, is to do with indigenous title to land, particularly the ownership of land. And it was always a problematic thing. And again, this is why Eddie Malvo, the gardener at JCU, had to go to the High Court to try and prove this point. And funnily enough, the guy who was pretty much the equivalent of me, who was the tutor for all of the business law subjects back in the 80s, was talked to him about it. And the exact expression that he used was, "Mate, you don't have a snowball's chance in hell." And that's because the Australian jurisprudence in this particular area about terra nullius was, factually, that's wrong. Yes, there were people living here. Yes, we accept that those people lived there and they had things, but the courts have decided this for a long time. And they've said for 150 years that we don't recognise indigenous title in this particular land. That terra nullius, while it may have been a myth as such in relation to Australia because people did live here, we're not going to recognise it. And so the High Court, I think it was a 6-1 decision. You have big cases like this in the High Court, they'll have 7 judges, and they'll go, and sometimes they'll have joint decisions together, and sometimes they'll have individuals. Some judges in the High Court love to hear their own voice, and they will almost always write their own judgment for every single matter, for better or for worse. So that point that came up there is that because they had to talk, it's a very long, very, very long decision, and they had to talk about the way the common law works. And so that this is this idea that where Englishmen establish themselves in an uninhabited or barbarous country, they carry with them not only the laws, but also the sovereignty of their own state, and those that live among them and become members of the community become also partakers who are subject to the same laws. What they're saying there is, when the British would come somewhere, like this, and for whatever, in any of those three mechanisms, either through terra nullius, or through treaty, or through conquest, that the British system sits on the top. And so the existing laws and legal systems stay there until they're expressly changed. But there's a great cartoon, I should put it in the slides actually, of Blackstone's commentary. There's a famous English jurisprudence guy called William Blackstone. And the comic has, old school English boat with people coming out with this big book, and it's got Blackstone's commentaries written on it. And the indigenous people are saying, the locals are saying, are you scared of all the boats? And they're like, no, we're scared of what's inside that book. Because the idea is, and this is the key concept to take from this, is that the law is considered received in that land at that period of time. All right? And from that point afterwards, that's where all of this adaptation thing starts to happen, where they either go and extinguish particular laws of that land and replace them with British ones, or often they adapt the laws of ye olde England to the local system and structure. Because if you think about it, Britain, little island, not a huge number of people. Come to a place like India, lots of people, lots of established structure. These laws aren't going to be applicable here. A lot of them aren't. They have to be adapted to deal with large quantities of people and infrastructure. Coming to Australia, Australia has a lot of land. And so the way that land law has developed in Australia is very much parted ways from the way that the British would go through and do things there. Does that kind of make sense? Does that kind of make sense? It's this idea of the parting of the ways that happens. The laws need to be adapted to the local conditions. And they're received at the point in time, again, either through treaty or through conquest or through terra nullius. And the year that happened in Australia was 1788. When they come and say the laws now apply from this particular point. And it wasn't until 1992 where they were like, oh, yeah, sorry about that. We didn't do that very well. Yeah, we need to fix that somehow. The way the High Court fixed that, by the way, because this claim was only in relation to native title. And they said, if you have a long-standing connection to a particular area of land that predates all the way back to before 1788, and no one's come and kicked you out of that land, then yes, you have some form of native title claim to that area of land. That is a really high bar. If you think about it, how many parts, even in a country like Australia, which is quite large, would Indigenous peoples have been in, have stayed in terms of family connections for 200, just over 200 years and not been moved on? Because this is the real problematic thing with native title. It doesn't matter how you've been moved on. Whether you've been moved on because you've given a whole pot of money, or whether you've been moved on because there were some skirmishes with local farmers and they've come and had had massacres, literally massacres. Any of those things breaks that chain in native title. It's a very, very difficult system. Okay. Now, there are a couple of other things to note there. Notice that the quote that he's having there, it does seem a bit strange to talk about Englishmen in 1992. This is a pretty common thing, the way that judges operate in our common law system. They don't like to think of themselves as making law. Judges don't like to think of themselves in the common law system as being the ones who make law, even though arguably in that case they very much did. But the way that they go about doing their job, remember it's Parliament's job to make laws. Parliament are democratically elected, you pass things through Parliament, that's the way that it operates. So when they're quoting these things, they're quoting previous decisions and what judges have said in similar situations. And we'll talk about that. There's actually a specific name for that. They call it the Doctrine of Precedent. We're just following what earlier judges have said. We're not really making up anything new. Now, it's a little bit of a lie. They kind of are, because they're picking something from here and something from here, not something from there and something from there, which might say something different. It's not quite as problematic, for want of a better word, in the Australian system. It can be quite problematic in the American system, because not only do they have lots of precedents to pick and choose from, they also have a lot of rights enshrined in their constitution. And so you can just read and interpret the constitution in a particular way in order to apply it in their appellate courts, and that can be a little bit problematic. Okay. Now, and again, this is a substantive topic, so I've got to literally explain a whole bunch of concepts to you guys here. So that first one is this idea of reception. It's when the British come, or any particular nation, either through one of those three means, and establish their laws in a particular place. And under the Westphalian model, by default, the laws of the indigenous or existing peoples don't change until that's expressly happened, until that's expressly been done. Okay, but there is also this idea of sovereignty. If you come to a land and you've either conquered it, or you've gained it through treaty, or there's no one there, by default, you are the sovereign people. And it's that idea. We don't want to have multiple sovereigns as well. Now, one of the kind of problematic, I'm going to switch the slides. This is the hardest slide to try and explain probably in any of the classes I have to teach. One of the worst things about the English language is the same phrase having multiple meanings. And unfortunately, lawyers, and when reading your textbooks, unfortunately, even Steve's a bit guilty of this, don't clearly explain the phrase common law actually has three different meanings. You guys are a bit brighter than the average first-year business students, because you've been in these sorts of systems for a bit longer. But the confused looks when I try to go through this and explain this to them, and I'll explain it like 3 or 4 times and then realize I probably shouldn't be assessing them on this. This is frustrating. It's a frustrating thing. I wish they'd use different words for it, but they haven't. When I use the term common law, there's 3 different ways that you can describe it. First thing is as a legal system. So I think I mentioned this last week. Australia, New Zealand, Britain, the United States are common law legal systems. And the best way to think of each of these 3 meanings, by the way, is to think in terms of what are the opposites to it, or what are the other things that it is opposed to. And so that is different from civil law systems like they have in Europe, in fact, in most places in the world, where they have these codes and they codify everything. And that's different from, a little bit different from socialist systems, but they're kind of civil systems as well. And different again from religious systems, where everything flows from the divine text. And that's where religion law flows from the religious beliefs. So that's what we're meaning here. So that's the fundamental type of system. In a common law system, judges are a source of law. All right. And so that's also the idea of when we use it in the secondary sense. This idea that when we're trying to find rules, sometimes those rules come from a statute. And again, in civil law countries, they all come from statutes. Judges aren't a source of law. But in our system, most laws come from legislation that Parliament validly passes. Some laws do come from judges. And so the example that I use for statutory interpretation actually is the word possession in our system comes from a High Court case in the mid-1980s. So if ever you're the definition of possession is that something that is within your control, and it can be in your control if it's there, if it's outside my arm's reach, or if it's sitting in my office upstairs. It's all about, there's a mental element to it, and the courts went through and described this in a case of Hicote in 1980, I think it was 85. Now, another example was the Malvo Decision. When we're thinking about native title, that essentially became a source when they said, oh yes, there is native title, and yes, if people do manage to have that long-standing connection, then yes, they ought to be able to claim that. And yes, we recognise the existing peoples had their own legal system. And so you could arguably say, at that point in time, that is judges making law. They don't like saying it themselves. Apparently it's this great insult if you tell a judge that they're an activist and responsible for making the laws. They go, no, we just interpret the law. That's our job. Sometimes they do essentially make it. But judge-made law can never have the precision, the robustness, the length, and the detail that Parliament-made law can have. And the reason for that is that judges are finite and few, and judges never get off their seats. They don't go and investigate, and they can't raise revenue. They can't actually go and hire people to go and determine native title claims, for example. So that example of the Malvo Decision, the government of the time, they had to make a decision. Do we create legislation that reverses this? Or do we go with this and actually set up structures and put in place systems and have create forms that people need to fill in and have a bureaucracy that people need to do to make native title claims? And they decided to do the latter. So in 1993, they created the Native Title Act for Indigenous peoples to be able to make those sorts of claims. Because judges can't do that. They can operate as a source of law, but they can't do all of the itsy-bitsy stuff that we need to do in our society to actually make things function. And so, just going back to your assessment. So when you're going through and looking through your assessment, you will find very little judge-made law in terms of the structures that are in place. Even though it's to do with going to the courts, they're not the ones that determine what the fees are to apply to the Supreme Court, or how long do you have to wait or to go to mediation, and who's going to have to pay for this? These are not things left up to judges. They're solely the domain of Parliament. Okay, and the final one is the pretty obscure one, actually. This hardly ever comes up. When we're talking in some areas, particular areas of law for this subject, contract law, for example, there are some rules that are judge-made and also made by Parliament as well, to some extent. And we actually contrast those with what we call the principles of equity. And this is usually clear as mud at this stage. It gets a little bit clearer later in the semester. But turns out, in our system, where you would think the judges are only there to fill in gaps where Parliament makes mistakes, right? Well, for a long time, there was another group of people that would fill in gaps where the judges made mistakes. And they were the priests. You actually had the clergy have a separate area of law where you could literally walk in to they called it the chancery, the courts of chancery, to solve or to bring an action where you couldn't do it in common law because everything was quite rigidly defined, either through statutory rules or through judge-made law. Now, those rules and principles, many of them still apply in this day and age. And when we're doing contract law, I will talk about some of these equitable principles and how they pervade the system, even though, as a person that studied business law myself and did a business degree, I had no idea what they were talking about. And I'm hoping by the end of this course, you guys will know more about the way equity works than I did back when I finished this. Just the key thing to note, again, stupid English language, the word equity has nothing to do with the equity that we learn about in accounting. They're completely different terms, unfortunately. Equity in law is referring to a set of rules and principles designed originally by priests to remedy the harshness of common law rules, to essentially fill in the gaps. Okay. All right, so thinking here about the court system that we have here in Australia, and I've mentioned before about this idea of that they do have a bit of a lawmaking function. They don't overtly say that they do, but they kind of do. I filling in the gaps between what Parliament's done. And look, it's really hard as a Parliament coming through, creating a new law to try and map out every single possible permutation that can happen. Turns out people are really complicated, and how we deal with things can be really, really complex. And in my mind, the whole reason the legal profession exists is because that complexity is something that Parliament can't keep up. Who has taken an Uber recently? Hey, anyone else? Only one. Really? You guys don't take Uber or taxis? Has anyone taken a taxi recently? Taxi or an Uber in Australia? I laugh when I think the first Uber I took was only about 6 months ago. I didn't have it on my phone. I went with a friend. I was in Adelaide, and I said, wouldn't it be funny if the first time I went in an Uber, the guy ran me over? So I stepped onto the thing with the car and he ran me over. He's like, please don't give me bad feedback. I'm like, no, completely my fault. I was being an idiot. Anyway, Uber is something that Parliament hasn't kept up with very well. This idea of the gig economy, it kind of crept up on them really fast. So much so that they had to sort of hurry to try and legislate things without really understanding how the thing works and what the benefits are, what the advantages and what the disadvantages are. And the whole thing was a bit of a mess, to be honest. And that's because it's complex. It's complex, and Parliament, they try to make laws prospectively, but occasionally the world changes faster than they do. They don't sit for many days in a year. They can't pass that many rules and laws. And so they can't be perfect, and they're not. And so the judges do have to fill in those gaps from time to time. That's this law-making function. That's not the primary function of judges in our system. Function of judges, or courts, as I describe them in the broader sense, is to adjudicate. What do I mean by that? We have what's called an adversarial system. That means when we go to court, there are two sides fighting it out. There is a winner and there is a loser. And it sounds really harsh, and that is fundamentally how the legal system here operates. Now, it can be either two citizens coming together, or it could be a corporate body, or it could even be a government department. In the case of Malvo in Queensland, it was actually the state of Queensland was the respondent, in a civil matter. But essentially, two sides fight it out, and the judge remains impartial. They hear evidence from both sides, they hear legal argument from both sides, and then in civil matters, usually the judge sits alone to determine who wins and who loses. And, key thing to note, tuck that on the back of your mind, costs. Really important thing. And the nice thing is about you guys, this is one of the things I love about teaching the business students as opposed to the law students. You guys have no problems at all with numbers. Law students have this just as a general rule, are terrible with numbers. Just the looks on their face when I start doing write very, very basic things on the thing. Oh, well, $180,000, divide that by 2, and you just get, whoa. You guys, I think, appreciate and understand how risk works, and the relative cost in terms of interest rates that need to go with things like investments, but also in terms of costs that can be fired back against you if you lose. Because the default rule is, in civil law, when one side's suing another side, the winner pays the loser's costs. Now, I'm just going to explain this because I think it's a really useful piece of information, and you'll need to think about it for this. Winner pays the... Hang on, sorry. Did I say the winner? I said the other way around. I said the right way around. Sorry. The loser pays the winner's cost. I said that completely wrong. Sorry. I'm going to blame the fact that I've been bedridden for 36 hours for that. But a couple of things you need to know in Queensland, in fact, all jurisdictions in Australia, is that when you lose, yes, you pay the other side's cost, but you don't usually pay all of their costs. You pay what's called a fixed rate. We call them scale costs. They are established and set out in a piece of legislation and regulation, which I think is the Supreme Court Act, but that's for you guys to go and find out. Now, what happens though if you are bringing the action and you send a letter out to the other side, we call it a letter of an offer to settle to the other side, and the amount that you offered it for them to pay you in order to settle the matter, right, is this much. You go to court and you win this much, all right? they have to pay your costs on what's called an indemnity basis. That means they pay all of your costs. Now, for you guys, in terms of business students, this is a really important rule that was not in the subject, and I'm telling it you now because it is super important. If you are bringing an action in the court and you offer to settle for an amount, and the other side gives you the two-fingered salute, tells you to go away, and you end up going to court and you win more, even if it's just $1 more, they have to pay your costs on what we call the indemnity basis, which is all of it. All of your costs get paid for by the other side. So what that means in terms of doing a cost-benefit analysis, offering to settle is a very powerful mechanism to avoid going to court. And any lawyer worth their salt will tell you at all costs, that probably doesn't make much sense, you should very much try to avoid, in most situations, actually going to court. It is expensive, it is stressful, and at the end of the day, two sides have come to court, both thinking they're going to win. Only one of them is going to walk out winning. And the side that loses pays their costs, either on the scale or the indemnity rate. And that's a really, really important feature. And again, business students, I think you guys appreciate it a little bit more because these are the sorts of things that you guys are likely to be directly involved with. You're going to have suppliers who haven't paid you. You're going to have, employees. No, not employees ripping you off, but you're going to have customers, suppliers that haven't supplied you, customers that haven't paid you. I've got that mixed up. You get a point anyway. People are going to do bad things to you at some stage. Maybe they think they're doing the right thing. Maybe they think that you're doing the bad thing. Either way, knowing how the system works is really important. I think it's a really helpful thing to know and understand that at this stage as well. Okay, just the final thing to note, that point there too. In the olden days, magistrates were also the keeper of His Majesty's peace, or Her Majesty, depending whether it was a queen or a king in power. It's been a queen for a very long time. Very, very long time. It's been very, very strange when that changes, because the whole lifetime of my parents, not just me and my son. But judges also issue warrants. They are the ones who have the power to get members of the executive to go grab people, physically go and detain people. It's actually a really important mechanism in our system. The executive, wherever we possibly can, we try and stop them from directly being able to detain people. So this idea of having judges in a position to be the ones that have to sign the warrants, it's a really important thing. So even if you're wanted for some heinous crime, right, it's still, for a person to be able to come into your house and grab you and take you away, that has to be signed off by someone in the judiciary. It's just a key notion of our system. And if you have been detained, there's a part in our law that goes all the way back to Magna Carta called the writ of habeas corpus. This idea that fundamentally the Crown, the executive arm of government, doesn't have the power to arbitrarily detain people in our system. You can always apply to the courts for a writ to make them bring the person before the courts to hear the charge in the criminal system. It's a key thing to note here. Okay. I'm not going to labour too much on the next slide. It's just basically restating this idea that when we think about these two broad categories, we've got the party name and a little v. We've got the criminal matters, which are brought by the state of Queensland, if you're in Queensland, or the Commonwealth, if it's under the Commonwealth legislation, or one of the enforcement bodies, like the Queensland Police, for example. Criminal matters, curiously, can actually be brought by other organisations. In fact, the associate professor in the law school here, Dr. Louise Floyd, she is this passionate and animal-loving type, and she, from time to time, gets called up by the RSPCA. The RSPCA is the Royal Society for the Prevention of Cruelty to Animals. They actually have statutory power to bring about criminal prosecutions where people have misused or abused animals. So she, from time to time, actually suits up and goes to court. She actually goes and prosecutes on part for that, which is pretty cool. But it's pretty rare. Generally, matters, 95% of all matters are brought about by usually the Queensland Police in the state of Queensland, or if the matter is serious in the criminal sense, it's brought about by the what we call the Office of the Director of Public Prosecutions, or the ODPP, or usually just the DPP they're called. That is, if the matter is so serious that you need to go straight to the district court. If it's sufficiently serious, so something like grievous bodily harm, you chop someone's hand off, or rape, or serious drug matters, supplying large quantities of drugs. All of those things need to go to the district court. And the next slide is not the best diagram, but we should be able to work with it. This is the Queensland court structure. Yeah, it's not the best, but it's not terrible. We got that? Okay, so it's a useful place to start anyway. Okay, so a couple of things to note. And I talked about this a little bit last week. Simple matters, small matters of a criminal nature, or what we call a quasi-criminal nature. Things like parking tickets. If you want to challenge a parking ticket, like I did one time, you don't do it. Don't do it. So it's not good. Doesn't end well. If I knew things are really bad when you're walking in, you see the magistrate's name on the door, I'm like, oh yeah, no, I've lost this one. But if you wanted to if you're brought, or summons is the technical term, a little document called a summons, which again has to be signed off, usually by JP, that orders you as a person to come to court. You must attend court to hear a series of charges placed before you. That is in the Magistrates Court in Queensland. Now, these names actually vary. All of the states have different structures, so it's not particularly important to know the other ones. This is just what we have here. Whether it's the best system, I don't really know. But the key thing to note is that simple criminal and quasi-criminal matters are in the Magistrates Court. Strictly speaking, even the very serious matters actually start in the Magistrates Court because they have to be brought to there to determine whether this matter is to go to trial or not. It's the place where they go to book the correct court. So the police will rock up with a particular charge and say, this needs to go on indictment. This person's hacked another person with a samurai sword. This needs to go to the district court to be heard. Or, if they died, we need to go to the Supreme Court. And so originally they rock up to the Magistrates Court. The magistrate will hear the matter and go, okay, sure, yes, this matter will be set down for this particular date when the Supreme Court judge is back, for example. Civil matters, small civil matters start there as well. The next slide's got the amounts on there as well. So very small, when I say very small, less than $150,000 matters start in the Magistrates Court as well. If you don't like your decision in the Magistrates Court, then you can appeal to the District Court under Section 222 of the Justices Act. And your matter, and it's actually one of the more interesting things. I did a placement with the DPP in Townsville, quite a few years ago, 6 or 7 years ago. And what they find is that people that go to Magistrates Court to try and get off their parking tickets, or whatever the particular offence that they're doing, and then they want to do an appeal. Our system is set up to allow people, as best as possible, to represent themselves. We don't recommend that you do that. We don't think that on average you get the best outcome, but you can do it. Now, the DPP, they have to deal with the appeals. The police or the Townsville Council or whoever's bringing the matter in the Magistrates Court, they don't deal with the appeal. They just deal with it, whether they win or lose. If they lose, the person doesn't usually appeal. Sometimes the council will appeal if they do win, but assuming that they lose, and the person aggrieved by a decision, how dare they charge me $1,000, $958 for as a costs order for trying to defend their parking ticket. You can then appeal to the district court, and the DPP will deal with it. They will be the other side, representing either the council or the other side in that appeal. One thing the DPP guys got, they refer to these as Magna Carta appeals. Why? Because often the people bringing about the appeals aren't legally trained, and so they will draw in all sorts of rules and laws that make absolutely no sense whatsoever. They'll talk about the American Constitution, they'll talk about the UN Declaration of Human Rights, they'll talk about the legal system in other states, they'll talk about the Magna Carta, they'll talk about all of these things that they've seen on crime shows. It can end up being a little bit messy. And also, by and large, you get cost orders put against you if you do go and do that. So it's something to be mindful, particularly on civil matters. Be very, very wary. Be very sure of yourself before you lodge an appeal. But you can do it. Now, if you're in the district court, either from one of these appeals, you didn't like your decision in the magistrate's court, or you've just come there because your matter, maybe you're the person who attacked someone with a samurai sword, and you've been found guilty, and you've been sentenced to 5.5 years in prison, and your lawyer turns to you and says, look, we think there's been some evidential problems here, we're going to lodge an appeal. So you can, if you're in the district court, or if you brought a matter in the Supreme Court, in other words, the same situation, but the person you attacked with the sword died, so that's a murder charge, or manslaughter, or murder charge. That's a very serious offence, as you could imagine. But if in either of those situations, if you think there is a defect of law, then you can appeal. All right? You can't appeal findings, what we call findings of fact. And that's another super, super important point, because in a criminal matter where you attack someone with a samurai sword and then someone's very, very badly hurt, that will be heard by jury. You ever know what a jury is? Vaguely? Jury? It's 12 members of your peers. So they get, usually they summon like 50 to 100 people and then choose 12 to sit on a trial or a series of trials that can last for up to a week. Now, juries, if you guys do get the chance to sit on a jury, I don't know how it works in terms of residency. I think you have to be on the electoral roll, which means citizens. You probably have to be citizens, I think, to sit on it, I would think. I've never been allowed to sit on a jury in Australia because I already had a law degree and I was a practitioner before I became a citizen. So once you're a legal practitioner, you can't sit on a jury either. Well, unless they forget to ask you, which is what my old boss did, who used to be the head of law here, Paul Haverman. He was working in New Zealand, and he was in Hamilton, New Zealand, and he got summoned for jury trial and got called up. And they never asked him what his occupation was. And he wasn't a legal practitioner in New Zealand. They never asked. But if they did ask him, he would have said, oh, I'm the head of law at Waikato University, but no one ever asked. So he thought it was lovely. He sat on a jury trial for a week. But generally, if you're a legal practitioner or a JP, or you're, I think actually if you've been convicted of indictable offence and you've gone to prison for a length of time, you can't as well. But yeah, you have to be on the electoral roll, which means citizen. Yep.
But that, if you wanted to appeal a jury decision, you found out something like one of the jurors were law practicing. Would that be a reason?
Yeah, that's right. That's not, because that's strictly speaking not an issue of fact. That's a question of law. It's to do with the fairness of the trial itself. The whole point of the system that we have, and the reason why trials in the criminal sphere are so long. Has anybody had to sit to watch one of these things? Actually going and watching a criminal trial, you can literally go to the opening arguments on the Monday and come back and they're halfway through, Thursday afternoon. They can take a really, really long time. And it's not uncommon for jurors, for whatever reason, to reach a point where they're just like, no, I can't do this anymore, and they don't come back again. Now, most jurisdictions have a bit of leverage in terms of usually one juror doesn't want to do it anymore, then that's fine. We'll carry on with 11. When it's more than that, then no, it's just too much. And so the tricky thing happens when jurors are subject to immense pressure from all sorts of areas. Anyone heard of a person called O.J. Simpson? I don't know if anybody here is of my generation or earlier, but O.J. Simpson was an American footballer. He played gridiron. Very, very good player. I was just reading about him the other day. Really good player. In the 70s and early 80s, decided to change to be a movie actor, and he seemed to be moderately successful as that. Anyway, sometime in 1992, an incident occurred, and his wife got brutally murdered, and in circumstances where there were no other people around, and he had blood all over his hands and he'd hidden a knife somewhere, but nonetheless, it went to a jury trial, and the jurors were put under extraordinary pressure throughout that. The trial was outrageously long, and they dropped like flies. They eventually reached this point where so many jurors had quit that they couldn't carry on having the trial. So he ended up being acquitted of the criminal matter of murder. But the relatives, the family of his deceased wife, took a civil action against them and won spectacularly and sent him bankrupt. So much so that he ended up robbing a bank about 12 or 13 years ago, or a casino, and then went to jail anyway for like 8 years. So he's out these days. I don't know what he does, but anyway, that's what can happen to jurors. Jurors, in our system, they are sacrosanct. In fact, if you are in the courthouse, jurors have their own special entrance and exit to the courthouse itself. If you're on a jury panel, they'll go in and you're not to talk to them. I had the unfortunate moment of needing to go to the courthouse to talk to Robin, who's what's called the registrar, the senior administrative person in the courthouse, and go through some cameras, because a couple of students were taking notes on a trial, went up to the jurors, one of the jurors afterwards, who was falling asleep, and said something along, I'm paraphrasing, "You shouldn't be falling asleep, a man's life is at stake." Something like that. I don't know, I didn't hear that part. So I had to go through to try and identify them. Turns out they weren't JCU students, so I was quite happy about that. But it still made the papers. And because the entire trial had to be redone at ridiculous taxpayer expense. You think about how well paid all of the people in this room are, and having to have this room and having to have all of the structure around it. Well, if you've got a trial that takes 10 days and it gets kicked out, I mean, you've just cost the Queensland government, $50,000 to $80,000 plus, depending on how expensive the various private barristers are as well. So that's why they tried to insulate jurors as much as possible from the rest of the system. Okay, if you don't like your decision, and again, what the jury thinks, if they reckons that she's lying and he's telling the truth, that's how it stands. That is a question of fact. You can't appeal issues of fact. That's a key part of this. The only reason you can have an appeal is that there is some legal defect. And that can be procedural. Again, the juror turns out this juror is invalid. That's a procedural problem. It can be evidential. So that piece of evidence that was put before the jury, that was obtained unlawfully. The police have snuck in at the wrong time and grabbed and taken it. You can't do that. You have to have a warrant. And if that was put before the jury, that is prejudicial to the whole trial. And therefore, we're going to do it again. That is an error of law. They can be appealed. Quite often, by the way, in a criminal matter, if there is that sort of defect, rather than the person getting off, they just send it back to the court that it came from, either the Supreme or the District Court, and tell them to do it again. Do it again, which is, again, very, very expensive. And again, while I was at the DPP, I sat in on a matter, it was about a guy, this was in 2012, who'd had his baby daughter and was accused of grabbing her and throwing her onto a table. And she died, brain injury, and then died. So it was a horrible, horrible thing. That was the third time it had been to trial. So it happened in 2007, and it went to court, went up, went back, went up, went back. And yeah, that was the end of December 2012 that was heard. So these things can take a really, really long time. Yes?
Is there a limit to how many times you can go?
No, not in terms of, not legally. That's right. There is a very important rule to do with bringing the action twice. If a person is found either guilty or not guilty, and the matter is done, the police or the Crown prosecutors can't bring the same matter, criminal matter, up again. It's called issue Estoppel, or we call it the principle of double jeopardy. You can't be accused of the same matter twice in the criminal sense. So if something's happened, you've gone to jail for it, and then you've been found guilty of it, you can't come back again. This can be a little problematic and a bit technical, where, for example, a person's committed a series of bad crimes in the same transaction, essentially. So a person's gone on a theft spree from here to Cairns, or run around stopping at service stations, beating people up, run to the next one, beat someone up. So you've done a series of these things. In fact, the quite tragic case was in North Queensland, in Phillips, which was to do with rapes, where a guy had a series of rapes. The difficulty is, if there is this series of matters and they're all heard at the same time, if there was one where the complainant doesn't come forward until after this has already been done, that can be a little problematic, because they can turn around and say, well, look, if you'd come forward earlier, this would have been heard as part of this. And so they can end up being quite technical in terms of whether it gets included or not included in the criminal sense. Criminal law, by the way, can be quite interesting. It's also quite heartbreaking. It can be just really soul-crushing. I've known this from my friends who do criminal law. After they've done it for a long time, they end up talking about quite horrible topics, just very matter-of-factly. Oh, yes, well, we got the knife, and then we split it like this, and didn't do it like this, but it didn't do it like this. And it all becomes very much, they're doing it in terms of a technical legal thing, much like doctors. You get used to blood going everywhere. After a while, I'm squeamish as, but I could never be a doctor. But that's just the nature of the beast. I think you just get used to it. Okay, other things to note here, by the way. So the Queensland, if you don't like your decision in any of those two courts, Queensland District or Supreme Court, you can appeal to the Queensland Court of Appeal. If you don't like the decision there, you can go to the High Court, but you must seek leave to appeal. That means you have to prove that your matter is somehow special or important, or there is some grave injustice that's happened as a result. You basically have to impress a handful of High Court judges in a special session that they set up for you. That's really the key thing to note there, this idea of leave to appeal. Now, when I talked about Magistrates Court being small dollar values, all right, up to $150,000, very, very small values, so up to $25,000 in certain areas, which you guys will need to know for this stuff, can be done in what's called a tribunal. Queensland's called the Queensland Civil and Administrative Tribunal, or QCAT. Now, QCAT has only been around for about 10 years, where they realised that Queensland had a whole bunch of tribunals, like 29 of them. Hey, how about we just reduce this to one and just give them powers to do all of the above? Oh, okay, that seems like a good idea. So they've done that. It's been reasonably successful. A couple of things to note. QCAT is not strictly speaking a court. Tribunals are actually part of the executive arm of government. They're not, strictly speaking, part of the judiciary. I've concluded them here as part of the court hierarchy because we kind of think of them as being like a court. They operate similar to a court. Both sides bring evidence, argue their case, and the person at the front, who usually has legal training, will give a decision. But strictly speaking, it's not a court. They don't have powers of things like contempt. They don't have an inherent power to send you down to the watch house if you're cheeky, which judges do. Judges have this inherent power. Literally, if you're cheeky to a judge in court, they can say, you, watch house, 3 hours. See you after that. They don't do that very often, but they can. A gentleman who was actually my local MP in Howick in New Zealand, where I grew up. Most of my youth was spent in East Auckland. was a local MP. When New Zealand moved to a proportional system, he lost his seat because the seats all got a lot larger. He lost his seat. And so he didn't want to be an MP anymore. So he started a business building drones for the US military. And I know this because his factory in East Tamaki was next to my dad's factory. And so I'd go and talk to him about all sorts of things. And anyway, his business went a bit sour and it got liquidated. Mr. Rogers' business got liquidated. And so it went to court. And the judge said, okay, Mr. Rogers, where are all these plans for these drones you built for the US military? They belong to the creditors now. And he said, what plans? And they said, you know what plans we're talking about. No idea what you're talking about, Your Honour. I don't believe you, Mr. Rogers, and sent him to prison, essentially, for contempt of court, for just blatantly, flagrantly lying to the court, and so he had to go to jail for 6 weeks. Then, of course, he got out, took his plans, and I don't know what he did with them, but yeah, courts do have the power to do that. They can send you to jail on a discretionary basis. QCAT can't, though. QCAT's a tribunal. A couple of things to note. QCAT's a lot cheaper, way cheaper than going to court. By default, you can't bring a lawyer. So QCAT's designed for people to go there and argue their case. And I had a matter, you're going to laugh when you hear this. When we do contract law, it's going to be really funny. I lost too, which is hilarious. One of the key things to note about QCAT, the rules of evidence don't apply. So the rules of evidence, things like the hearsay rule and unlawfully obtained evidence, but in particular for this course, we'll talk about a thing to do with contract law called the parole evidence rule. All of those rules don't apply. You can pretty much say anything you like about anyone you like, and they will pick and choose what they want. It's also inquisitorial. What does that mean? The judge can ask you questions of their own direction. Sorry, the judge, what are called? Member. The member can ask you questions. They're not strictly speaking called judges. In a court system, judges can't do that. Occasionally they do. Occasionally you will actually hear the magistrate just trying to resolve a matter. The magistrate's court, they will say, look, how old are you, Mr. Smith? I'm 23, Your Honour. And just go through these sorts of questions. What were you doing on the day? They will actually ask these questions, but strictly speaking, they're not supposed to. All right, magistrates will sometimes do this. Even higher court judges will occasionally do this as well to speed matters up. But strictly speaking, judges are not to question of their own volition to make inquiries to get evidence from the parties. That is up to the other sides to bring the evidence forward. In tribunals, they can. They can say, what were you doing? How did you get that? When did you read that? Why did you do this? Now, these matters can only be up to $25,000, and they can only, and again, you do need to know that for this, only if they fall under a series of categories, either a debt dispute or a consumer dispute. What that excludes are things like business-to-business disputes. So that's a key thing to note. So if you've got a business-to-business dispute where you're going to argue the facts, you can't go to QCAT. QCAT also have, as I said, when they merge those 27 tribunals, you've got the Legal Services Tribunal, and you've got the Mental Health Tribunals. There's a whole series of other things that go to QCAT. If your blue card gets refused, they have a special tribunal for that, and nurses have their own special tribunal for matters involving them. Now, similar to the court system, though, if you don't like your decision, you can appeal it. If you're only appealing legal matters, so issues of law that came up in your tribunal hearing, you can go and appeal by right. If you're appealing issues of fact, because you think that they were asking me all the questions and they didn't take any of these things, if you didn't like the evidence, the factual stuff, you can actually appeal that as well, but you have to, again, seek leave. What that means is that you have to prove that some injustice happened in order to do that. And it has to be worth the while. So me with my, I think by the end, my $89 stationery claim, I wasn't going to be able to seek leave because it was for $89. And the appeals tribunal is just going to go, nah, go away. But if it's only for issues of law, because they've only made a mistake in terms of the law, you can appeal that by right. You still got to pay $400. So yay, you can win $90, but you paid $400. Because by default, you don't get your filing fee back. There's a couple of things to note from this too. They can give it to you, but in my experience, they often don't give you the filing fee back as part of the decision. And the filing fee can be non-trivial. Go to the Supreme Court, that can be $750 or something. Okay. Also, if the QCAT decision in their appeals division, which is always done by someone who is a judicial officer, something, so that does kind of, again, it's not strictly speaking a court, but they have sufficient legal training to express it in such a way that if you don't like a decision from that, that can be appealed, again, only on issues of law, straight to the Queensland Court of Appeal. All right, that is fundamentally the Queensland system, and by default, everything is Queensland law. Pretty much everything you'll deal with from a business law perspective is going to be Queensland law. Contract, tort, agency. Only there are a couple of modules we do towards the end. One of the major areas that isn't Queensland law is intellectual property, which we'll talk about. We'll do a module in week 10 or 11. So that's the key thing to know. Again, maybe it may or may not come up in that piece if you do go through and have a look. All right. If you do have an issue with something to do with intellectual property, say somebody's breached your copyright. You've got a book. You've written and published a book. Somebody just copied large swathes out of it, plopped it in a book, put their name on it, and selling copies of it. You go, oi, you're breaching my copyright. That is fundamentally federal law. Copyright and intellectual property is federal law, and as such, to bring an action by default, you have to go through the federal system. Now, in a place like Townsville, they have a federal court, so you can go to, there is a federal court, it's on Walker Street, separate from the main Queensland system. And for a long time, we, being legal academics and people in the legal profession, thought that the federal courts could do what state courts could do, and state courts could do what federal courts could do. And it turns out, in the 90s, through a long series of one particular guy, it turns out that was wrong. State courts can actually hear federal matters, but federal courts can only hear federal matters. So federal courts can't, by default, hear state matters. They actually, there's a case, I probably won't talk about it now, but that's, so by default though, you trot along to the federal court, it operates pretty much the same as the Queensland courts in a whole host of ways, but it's stored in a separate building and they do matters that relate specifically to federal law. So just make note that the appeal system operates something quite similar, where they'll, if you don't like your decision, presumably you lost, or you didn't get the dollar amount that you wanted to win, and it's an issue of law, then you can appeal to what they call the full federal court. And that's basically where you get 3 or 5 federal court judges sitting together. They will review your decision. Again, if you don't like that, the next step's the High Court. You still got to seek leave. It's got to be some important matter. This one where it's got the Federal Circuit Court. Now that's changed names a few times. It was the Federal Magistrates Court. Now I think I'm not even sure what it's still called, the Federal Circuit Court. It might be. It's changed names 3 times in in 10 years. It's basically a baby version of the federal court, where they hear matters up to a certain dollar amount. Another thing to note, the AAT. If you have an issue with government department like Centrelink or the migration bodies or the tax office, those sorts of bodies, they have a system where you can have your matter heard out, thrash it out in a tribunal setting. Again, not with a judge, with a member, and they call that the AAT, Administrative Appeals Tribunal. They will hear that matter very much the same as QCAT will hear your matter in the Queensland sense. They'll hear it, thrash it out, ask you all sorts of questions, rules of evidence don't apply. If you don't like the result, you can appeal to the federal court for issues of law. Okay, and finally the last thing, doesn't really come up to this thing, and we'll stop it. We'll take a break after this, is the family court. Family law is huge in Australia. It's a big chunk of the legal profession in terms of the amount of work. And it has only existed since the Family Law Act came in, since 1975. It's a relatively recent area of law. These days, creates a lot of wealth for a lot of legal practitioners. I might leave it at that, but just note, in other jurisdictions, and I'm thinking particularly of India here, issues to do with the family that historically and traditionally were left, behind what goes on behind closed doors stays behind closed doors. The courts don't get involved with those things. That, in what we call the sort of the developed nations, has changed a lot in recent times, in the last 30 years. And one thing I've noticed with a few of my friends who are practitioners in the subcontinent is that's something that's starting to change there as well, slowly. But I won't get too much into family law because it's long-winded, complex. They have their own court system. It's strictly speaking part of the federal court, but essentially they have their own specialist judges who deal with that area of law and their own specialist court of appeal. And if you don't know that, they go to the High Court. Okay, I'll flick the slide up. We're going to take a break. I'm going to flick up that slide. I'm just going to leave it, I think, because that has the dollar amounts in it as well. Somewhere. Leave that. 10 minutes? Is that about right? We'll go for 10 minutes. I'm going to get some food and drink. Sorry, guys, I've talked for a bit too long. working again. Don't know how that happened. Righto. Okay. So a couple of things to note when we're thinking about judges. This reads a little bit strange, but the whole point of judges in our system is fundamentally to interpret the law. And so we're in the pure sense, judges are not the ones that need to find the truth, the actual factual truth. They don't need to know, or are not supposed to, be what we call the arbiter of fact. In a perfect world, that would always be up to the jury. But juries are expensive. Just imagine if every single legal matter that went before the court system had to have 12 very bored-looking people listening to it. It would get really dull. It would be the whole thing would fall apart. It'd be way too expensive, especially in places like Australia, high-wage economies. You have to pay, if you do get to be on a jury at some stage, you actually do get paid, but it's not a lot of money. But still, relative, I suppose. Has any of you guys been on juries? Is anybody? Yeah. Did you turn up on the day?
No, I didn't have to. I had to send a letter to say I was available.
Yeah.
Or a letter to say I didn't fully need it.
Oh, okay. Got the not leave. Yeah. Thanks, but no thanks letter. Yeah, sure. Okay, yeah. I once went. I got the letter to say come to jury duty, and they pay you a little bit for just turning up. All right, for a few hours to go through the selection panel. As I said, there were like 50 people, and they call out the names, and then they called out my name, and as it went to. I'll never forget this, because usually in a criminal matter, the defense staff, they're the ones trying to work out who do we want to get rid of, because they have usually a finite number of challenges where they can just say, for whatever reason they feel like, don't want you. Right? Either side can do that, but traditionally, the prosecution don't care. And in Queensland, I said, spent time with the DPP guys, and they're like, the only reason they would challenge people is to try and get a balanced jury. They would want to have a balanced, representative of the community in terms of age and ethnicity and so on. Now, if you are the defense barrister and you're choosing who you're going to challenge, almost always you want to get rid of people who look like they're going to be, think your client's guilty before they've even started the whole thing. People have prejudices. That is just a statement of fact. And so part of doing that I found really interesting is that of all of the people that were challenged, and when I went in there, it was 17 people got challenged. I was the only one challenged by the prosecution. Because all the rest were challenged by the defense, whereas I was a sloppy uni student, ripped jeans and a scruffy bag. And yeah, the prosecution were like, nah, not him. Not. I looked like I'd prejudiced the whole thing. But anyway, we can't have a jury trial all the time. We just can't. And so for most civil matters, with one exception, which is matters involving defamation. Defamation matters have a jury. All other civil matters don't. But with that exception, and all criminal indictable matters by default will have a jury. So anything in the District and Supreme Court, if it's a criminal matter, by default it'll have a jury. The Australian Constitution. One of the very few personal rights that you get in the Australian Constitution is the right to a trial by jury for all federal offences. So a federal criminal matter, you are constitutionally entitled to a jury. But in all the matters where there is no jury, the judge is having to serve two roles, to essentially wear two hats. One is as the arbiter of fact. The judge, wearing their arbiter of fact hat, has to work out who is more credible, who is less credible, who's lying, who's telling the truth, what actually happened in terms of the facts. Before we even talk about any of the law, We have to determine what the facts are. And so judges in matters where they're sitting alone without a jury, and again, this is most civil matters, will try as much as they can to map that out in a separate part of the judgment. This happened and this happened and this happened and this happened. I found this witness more credible than that witness, and this witness, more credible than this witness, and therefore I think that this is what happened on the night. Then they're going to go through and talk about the law and how the law is applied to it. And this is when they talk about this two-step process. This true facts thing is first done by jury if there is one. If there's no jury, the judge has to work out what the actual facts were in order to determine what the final result's going to be. So there's that two components. The fact component, who's lying, who's telling the truth. He said, she said, she's telling the truth. However that plays out. And look, a key thing to note, and this is for your own experience, particularly in criminal matters, the world is full of honest but mistaken people. I'll say that again. The world is filled with honest but mistaken people. When you are recalling facts that happen in high stress and times of your life, it is not uncommon for people's memories to not accurately be able to recall things. And that's why it's really important, by the way, if something traumatic happens and you need to know to write stuff down straight away. Even in this day and age where we have cell phone this and that, you know what'll happen in your life. Bad things will only happen when you don't have your cell phone on video mode to go and record it. Although I've got to say, those dash cams are making traffic matters a dream for insurers. Insurance companies should literally pay for everyone to have one of those little dash cams. Okay, so that's this key thing to note. The judge is really the tasked with these two roles in absence of the jury. Now, a bit of Latin. Okay. Silly story. My son, who's 8, loves Harry Potter. And so he challenged me to a wizard fight. And he's calling out all these Victimus, Mandamus, wizard things. I don't no idea what he's talking about. And so I'm just calling back to him, ratio decidendi, and stare decisis, and caveat emptor. Dada, you're being silly. I'm like, yes, that's just Latin phrases that I've picked up doing the law. So, a couple of things to note. There's 2 Latin phrases we use. It's just as technical terms here. That judges, even though they're not supposed to be making law at all, they kind of do. They are bound by decisions. And this is a key part of really the British legal tradition. Because back in the olden days, there wasn't a lot of statute law. Legislation's only a relatively recent phenomenon. I mean, there were some, but not many. The king would produce these things, once a year. One piece of legislation, they have 5 different rules in it. But the rest of it was up to the judges. But the key thing to note is that judges are always bound by decisions of superior courts, earlier decisions by superior courts. It may sound like a bit of a sort of a trite rule, a series of rules, but fundamentally that's how our system works. If the Queensland Court of Appeal, and there's a good example we use for common mistake, Queensland Court of Appeal said something, it didn't go to the High Court. So at the moment, the rules for common mistake in contract law, it's a very obscure area of contract law, but you guys will end up learning it, is actually different in Queensland than it is for everywhere else. Why? Because the Queensland Court of Appeal said something which was different from what the Court of Appeal said a long time ago. They essentially sidestepped by arguing that this wasn't well formed. The High Court in an earlier case had misread or misunderstood what an earlier English decision was, and they mapped it out to say the exact opposite. So what you find there is, as a result, if common mistake comes up as a contractual issue in the Magistrates Court, the District Court, or the Supreme Court of Queensland, they're bound to follow what the Queensland Court of Appeal said, and not what the High Court said, interestingly, in an earlier case. These things doesn't come up very often, and I suggest that if that had gone to the High Court, they would have determined it one way or the other, and we'd be bound by that, but it didn't. Because judges, remember, they can't make people appeal their decisions. Usually judges don't want people to appeal their own decisions, but you can't make somebody pay a filing fee to go to appeal a decision just to make sure the law is crystal clear. No, that's not how the system works. Now, a couple of things to note, though, that this is a pretty hard thing to understand conceptually. Only the specific reasons that a judge has that determine the outcome of that particular case in a superior court are the thing that binds lower courts later on. So things that they say in the higher level decision that are unrelated or hypothetical don't bind subsequent decisions in inferior courts later on. So again, if we have a Justice and I we've gone to the Court of Appeal to determine our issue. We'll say that it's on the something technical involving the breach of contract. All right, and we're talking specifically about a very specific type of breach, and the Court of Appeal says, "Oh well, if instead of this being apples, instead you were using oranges, then I would have decided that way." Or, in relation to this matter, this other principle may or may not be applicable in this situation. These are statements that are said in passing, that are unrelated to the key reasons to this particular decision that they're making, that really renders the whole thing, as a result, one way or the other. So, and this is quite a hard thing to explain, sadly. I have to teach us the first years as well. I don't know why we teach the first years, but it's important for law. And so, the key thing to know is that, I'll flick it over. It's not to do with the facts as such. So the facts, if they are identically the same in a later case, the court in the later decision is bound by the reasons for deciding for the same facts. If the facts, however, are materially different, then they're not. Well, it's distinguishing by the facts. You're bound by decisions from earlier courts. This happens a lot, by the way. Again, Parliament can't easily map out every possible thing that happens in our life. They just don't have the time to go through and do that. And they're going to make mistakes. They try carefully to map it out. I was teaching trust accounting all of last weekend. I'll be teaching it in Cairns all of this weekend. And going through and reading what the Queensland Law Society wrote about using electronic systems for trust accounting is hilarious, because it reads like a person that knows nothing about computers has written this series of legislative rules for creating digital systems for trust accounting. And I looked at that and the analyst software developer in me just cringed somewhat. But they're not in a position to go through and map all of these things out. They're just not. It's hard for them to do that. Okay. And so just a couple of things. There are some other little rules that come from this too. If there's multi-judge courts, only when you've got, say, 7 judges and 4 of them rather, say one thing and 3 of them say another, reach the same result, only the ratio of this majority, the reasons for deciding for these guys, is going to bind later decision makers where the facts are materially similar. That's the sort of the fundamental rule for that. Yeah, it's clear as mud, this part. I've got to say, just conceptually, a couple of these things in the slides are just really hard to digest. And so it is quite useful, though, by the way. If anybody is here, is anybody available to come on campus? I don't know what you guys are in terms of your timetables, because you're more than welcome to come see me. I'm here sort of 9 till 5 or 9 till 2 most days. So if you do want to book a time to come and see me, admittedly, apologies for those that did try and book over the last few days, because I've been literally in bed for 2 of them. But it's worthwhile, because some of these things can take a few goes. You hear it like this and you go away and like, what was he talking about? Give it another go and just go through and thrash these things out a little bit. Sometimes it can help a little bit. All right, next step. Okay, completely different topic. Changing the topic quite a lot. Ratio discendendi and reasons for decision, that is judge-made law and how judges bind each other in terms of subsequent decisions. All right, that's called the Doctrine of Precedent. While that is important, the law students have to learn it, it's not really the dominant mechanism in terms of engaging with the law that you guys are going to have, I imagine, in your business and professional lives. What you are going to have is to deal with statutes. And by statutes, I mean both what we call legislative instruments, which in Queensland end with the word Act. So again, the one I was doing on the weekend was the Legal Profession Act, 2007. Competition and Consumer Act, 2010, Commonwealth. But also what we call legislative instruments. And these are things which Parliament's given the power to somebody. So they've got this act and they've given power to another body to craft what we call delegated legislation. The classic example of those are regulations. Because again, Parliament doesn't have time to go through and work out what the appropriate fee should be for applying to the court for this particular year. They ain't got no time for that. What they do have time for is to create a piece of legislation that says, there shall be a court, there shall be people that are in charge of this court, and those people have the power to create regulations for things like charging fees. Another example, the Transport and Other Road Users Management Act, TORAM, is the act that says councils have the power to fine people for parking. Right? The maximum they can fine them is something absurd. It's like 100, no, it must be 10 penalty units? Penalty units $138. The maximum the council can fine you is $1,300 for parking somewhere. That's quite a lot of money. And so when the council goes and crafts their regulations, they are capped. I think there's something in between as well. I think the Ministry of Roads, they have a regulation that says we now give the council's power to craft fines for their areas, but it's capped at 2 penalty units. And so when we actually get our parking fines, most of our parking fines are, anyone had a parking fine recently? Anyone have one from JCU? Oh, there's going to be some fun times. Oh, JCU. JCU's just changed their system for parking, and it's going to be hilarious, at least if the lawyers get involved. If you do get a parking fine, come and see me before you pay it. We'll have a laugh. I'm not saying you'll get off it, but we'll have a laugh. Okay, so Townsville City Council can only charge up to, I think, about 2 penalty units, which is $260 odd. And they don't even usually charge that much. Usually it's about 65, I think. I did get one earlier this year, I think, 60, something like that, just parking over 2 hours. Please? Oh, yeah, like that. What they try and do is the councils, by the way, I'd like to say that they're spending ratepayers' money wise, or you could also say they're a little bit lazy. They change them all at the same time. So they map them all out. So that you might have some dissident councils controlled by different political factions or whatever, I don't know, but generally they move those things up at the same time. It just keeps it consistent. Okay, so when we are reading a statute, now if you're unfortunate, I probably should have brought some statutes with me to read, but we can go through and pick. I can't really pick them up now, but too late. There's a couple of things you need to know when reading a statute. A statute, piece of legislation, does not read like normal English. There are specific rules you have to use in order to interpret them. So there's a couple of things you need to know. I actually wish, I can't easily do it now, but we may actually go over this again next week. I might actually bring along some statutory instruments. We'll spend a little bit, because next week's lecture is a bit short as well. Because when you're reading a statute and you see a word in that statute, and the word is, I don't know, possession was the example I used earlier, or road. It's a pretty straightforward thing. We all know what a road is. Well, it turns out when you're reading a statute, words, admittedly, by default, will have their ordinary and natural meaning, which you would think comes from a dictionary, but it doesn't. What it means is what we commonly accept a word to mean, and we can confirm that by looking to a dictionary. Wow, did that sound like I was just an exercise in semantics? Like I'm just twisting that around? The key thing to note, judges are really big on it. Dictionary makers don't write legislation. Parliament writes legislation, and if Parliament determines a word means a certain thing, it means that thing, regardless of what the English language does and changes. So you'll find that a lot of words actually have statutory definitions somewhere. either that will completely define a word, so we'll say, yeah, road means X, Y, and Z, or it can broaden an ordinary definition. A road means a road, as well as a footpath, a narrow beach, a trail, or something hacked through some trees, whatever the particular thing is. The Parliament can do what it likes. It can do these things to widen it, and sometimes it can narrow it and say a road means a road, except for roads managed by the Commonwealth government, for example. So that when we're using a particular term, it can be modified in some way. The really hard thing, which incidentally, if anybody here has a software background, these things ought not to be hard. I've been studying and teaching law for 10 and 8 years respectively, and it drives me nuts at the lack of hyperlinking in legal documents. It's ridiculous. It is absolutely absurd. There's no reason why you guys, as non-lawyers, can't pick up a statute, hover over a word, and say, oh, well, this definition of this comes from here, from this interpretive instrument, so like the Acts Interpretation Act, which is a really important statute, or it's come from the common law here, or it's come from these other decisions over here and here. It seems crazy that that's not the thing, but it is the thing, unfortunately. So when you're going through and you're reading a statute, and you see a word, particularly if it's a word that seems quite important in the context. So I tell you what, I think I might actually go on the screen. So apologies to the external students. I'm just going to pop to the screen. Oh, I know what to do. Oh, this is a little bit high tech. Me being super high tech. No, that's probably not going to work. Sorry, external students. I'm just going to pop to the screen. I'm going to maybe we'll Okay, here's a piece of legislation in Queensland. Google is real good at this. Didn't used to be this good. Now it's real good. So you can go and find, there's two main sources where you find legislation instruments. Both the first two searches in Google, which is great. Hostly is an open source, hyperlinked, inverted commas, plain text instrument for website. Created by a non-for-profit organisation, funded by the New South Wales Government, thanks to the New South Wales Government, that has and puts instruments from all over Australia. There's an equivalent one for the UK, which is Bailey, New Zealand, which is NZLE. There's one in the Pacific, which is Beckley, and I think PNG has one as well. I think. Not sure. Follow up on that. The idea is that it's all in plain text. It's got little headings and things like that. But the actual legislation that comes from the Parliament looks like this. Has the seal. And one of the nice things about contemporary pieces of legislation is that since the mid-70s, they've drafted them to be readable by members of the public. Because before the 1970s, seriously, legislation was not drafted for people to read. It sounds dumb, but it really wasn't. And so I, from time to time, teach tax law. And so tax in Australia is two federal statutes. And the old one is from 1936, the new one's from 1997. The new one is easy to read. Any of us could just pick it up, breeze through. The old Act is this abomination of triple negatives and convoluted language that is just horrible to read. So yeah, don't get caught up with that. Oh, you guys all have to do tax. Oh yeah, there you go. You all have to do tax as part of your MPA, I think. None of the MBA students have to, but the MPA guys do. Right, so the key thing to know about contemporary statutes in Queensland is that because they're structured all the same, it has the first few sections are all pretty much the same thing. It has the short title of the Act. Oops, scroll this down. It starts off with an index. This one's relatively long. Has anybody had to rent or had tenants in Queensland? Has anybody had to rent a room or a room accommodation? Most people have all, I think most of you guys have this. This piece of legislation governs the relationship, and in particular, the relationship in contract law. We'll start in contract law next week. This piece of legislation sits over the top. So everything we learn about contract law in this pure abstract sense, a lot of things are smacked down upon by this piece of legislation. It has a lot of power. It sees a lot of use, a lot of decisions, and a lot of court time is used up, or court acute time is used up in residential tenancy disputes. But just make note, the first few sections of most contemporary Queensland piece of legislation just have a short title, just this is the name of the act. When it starts, that doesn't help much at all. Fixed by proclamation when the government signs a little piece of paper. Who it binds? Usually this is not this complex. This one is a little complex because in residential tenancy, state housing is a thing. And so they don't want the government, strictly speaking, to always be bound by things in the Residential Tenancy Act. So they've specifically excluded certain government parts. And then they have an object section. This tells you the purpose of it. Now this is actually a lot more important than a bit of fluff. Where statutes have an object section. Oh, I could just move this here, couldn't I? I'll move this up here. I think we'll just object sections are really important because they explain the fundamental purpose of a piece of legislation. And that's really important because if there is ambiguity, if there is doubt, the courts, by default, are actually obliged, when interpreting statutes, to try and, if there's two meanings, and they can't work out which is the preferable one, because there's a bit of ambiguity, they are obliged, because of the sections of the Acts Interpretations Act, they are obliged to choose the one which is most in line with the purpose of the legislation itself. So that's why you'll find that contemporary statutes will have the purpose in there. It's more than just fluff. It actually has a very important technical reason for being there. Okay, and another thing to note, sometimes there's section 2, this one's up to section 6, definitions. Again, when we're going through and reading particular words in in this case a statute, often those words are defined somewhere else. So here we've got the dictionary in Schedule 2, defines particular words used in the Act, and we'll zoom all the way down to Schedule 2. This will have a whole bunch of words. Facilities for a room accommodation includes furniture and equipment. Fixed term agreement for residential tenancy means a residential tenancy agreement from residential tenancy. So these are particular terms that are used throughout the Act itself that have a specific technical and defined meaning for the purpose of the statute. You might also find with a statute like this one, because these are really designed to be read by people, ordinary people. This statute is designed to be read by the average person on the street to determine what their rights and obligations are in relation to residential tenancy. So what they've found in some statutes, they will actually have specific sections right at the start to define some keywords. It's actually pretty rare that this happens. This piece of legislation, they've bent over backwards to make this as readable for people as possible. They really have. And so that a couple of the keywords are for a person that's reading through the statute from beginning to end, which you, by the way, as a solicitor, you almost never do. You almost never read a statute from beginning to end. You usually find Control F comes up a lot. Rights and remedies of persons. We go to section 5. Finds all persons. Really interesting. What's the definition of person? Well, person has a specific technical meaning. It's not even defined in this Act. One of the hard things about statutory interpretation, again, without being able to hyperlink things, would be great. We could just hold the mouse over that and have it pop up the specific section from the Acts Interpretation Act that says, unless the specific facts or expressly stated to the contrary, person in Queensland means corporation, natural person, and any other bodies corporate. So if you see the word person in Queensland statute, it means companies as well. So that's the first sort of gotcha. How do we know that? Because very unfortunately, because it says there, How would we ever know that? Well, again, we probably wouldn't, unfortunately, unless, I don't know, we'd study business law or something along those lines. And look, that's why these things make it a little hard. But I'm hoping, and I admit it, I've been hoping for a decade, that they'll make these things a little easier in terms of learning to do it. Unfortunately, there are some forces in this world that, as we're aware, people respond to incentives in certain ways. There are certain forces in this world that have a strong incentive to make this difficult. Who are these people? Well, the lawyers, on one part, but also Thomson Reuters and friends, people that have the paid subscription services. And it is much more noticeable in the United States and going through their systems to try and find things. And to be honest, this was a thing in the British system as well. If you actually went back maybe 150 odd years ago, all of these published works that we have that are free over the internet, you had to pay money for them. And they would actually have people that would go into court cases and write things down and then sell those to barristers and to lawyers, sell those reports. They're authorised reports, get judged to stamp it and say, oh yeah, that sounds about right, and then sell those books. That was how they made money. So that, appreciate people respond to incentives. Okay. So there's a couple of things to note there. So residential tenancy agreement is an agreement. Agreement. Does it have a defined word? I don't know what it does, but is that defined? Is that defined somewhere in the Act? I'm not sure if it is. Sorry. The word agreement in here. Where is it? See section 19. Oh, there you go. Cross-reference. Excellent. Section 19. So it's a bit of zooming around. It's the downside of these things. You guys probably get a headache when I'm telling this too. All right. That's in this act, a reference to an agreement is residential tenancy, a reference to residential tenancy agreement, a reference to room accommodation agreement. Okay, so what they've done, they've actually got a closed term for agreement. Agreement is, when it's being used here, is specifically meaning one of those two things. So if we go back to section 10, definition of tenants, is it 10? No, really 12, sorry. It's almost a circular argument, but what they're meaning, of course, when the natural ordinary word agreement is contract. But here they're meaning a little bit broader, which a person gives somebody else a right to do something. And it's interesting that gives, because when we do contract law next week, if you give something to somebody, giving something to somebody, not receiving anything, it's not a contract. And so just make note that when we get start doing contract law, we're going to be doing it in the pure sense starting next week. But you're going to find that these sorts of instruments sit over the top and they change things. Fair Work Act changes employment law. Residential Tenancy Act changes residential agreements. The Competition and Consumer Act changes a whole host of things in consumer contracts between people. Contracts for the sale of land, contracts for the sale of vehicles, marine contracts, insurance contracts, all of these things have specific statutes that are set up to modify them. And this one is no exception here. The idea is, though, they tried to make it as easy to read as possible. There's a whole series. Has anybody actually gone through a header? Needed to? You've needed to do it. Something's gone bad. Something's gone bad. Have you had to go and read this? Either your tenant or your landlord. Anyway, I'll leave it at that for now. But, so a couple of things now. Oh, sort of statute interpretation. Okay. Okay. There's a couple more things. How much time we got? Oh, not too much. Okay, so it's just things to note. So the definitions for words can either be in the same statute or other statutes. Again, the most common one is that Acts Interpretation Act. So common words that are used often have either complete definitions or modified definitions in other statutes. So the ordinary definition of the word person probably wouldn't count companies, but when reading statutes, it does, because the Act's Interpretation Act says so. The definitions at the top, or sometimes they say at the top, there's a schedule at the bottom. Okay, sure. Sometimes, though, you'll find that definitions are changed only for parts of the statute itself. That can be a bit of a gotcha, where you'll say, oh, for the purposes of this section, a partnership means this. Tax, this comes up a bit in. Partnership, in some parts of the tax legislation, a partnership's considered a person or taxable entity in some places. In other places, it's not. Partnership is considered part of this, partnership's not. And so that can change and be moved around in different parts of an act itself. Okay. I'll go through these in time. All right. So that's exactly what the next slide says. Yeah, they just have. So again, this would be in a perfect world that it'll be hyperlinked, and you could be able to see the word. It would tell you and point to the correct one. In practice, they can't be bothered, or they haven't done it, and that's a problem for the technologists amongst us, I suppose. The just key thing to note is to be really careful. There are gotchas with that stuff when reading statutes, so just make sure you check and double check. The next bunch of stuff is I think is interesting. You guys might not think it's interesting. It's bloody awful. A collection of Latin phrases. We've only got about 3 slides to go. And these are the syntactic presumptions. This is one of the horrible things you find out in your first year of law school. When you're reading a statute, the English language doesn't seem to work in these sorts of places like it does everywhere else. So judges in their infinite wisdom have come up with specific rules of interpreting certain structures, lexical structures inside statutes. And what that means is that when you see words that are together in a certain way, that they take on a slightly modified definition in themselves. I'm not explaining this very well. So, for example, if I have the phrase, weapon includes knife, scimitar, katana, pocket knife, or any similar bladed instrument. All right. We're trying to determine whether a spade is a weapon. All right. What judges say is that when you're trying to determine what that open-ended or any bladed instrument is, because I mean, if you think about it, I suppose it's got a blade, I suppose. It's an instrument, I suppose. You can only determine whether it fits into that category by reference to the list of items before it. That's what the Justum Generis rule basically says. Where you have a list of items and then an open-ended class, the contents of that open-ended class are restricted to the logical category formed by the things in front of them. I'll start that again. If you have a statute that says it is illegal to have a taipan, python, that's not taipan, sorry, taipan, brown snake, cobra, or any similar venomous snake. All right, and you've rocked up with your python. All right, and somebody says no, that's a venomous snake, and you're like, oh, really? You know, maybe technically they've got yucky stuff on the back of their fangs, and they could give you a bite, and it could get infected. And so, when interpreting a rule like that, judge will look at it and say, well, okay, you've got this open end or any similar snake. Say any similar snake. When we're trying to determine whether this is a similar snake, we look at the logical class formed by the things before it. Taipan, brown snake, cobra, death adder. I don't know if you guys know much about snakes. I'm a Kiwi. We're terrified of snakes. And I've had to, It's taken me a long, I've been here 12 years, and it's taken me a long time to get even comfortable talking about this. So, judge is going to look at this, see this open-ended class, and know that it's restricted to the logical category of things formed by the list of items before it. That's essentially what that rule is saying. If they say, or any snake, or any similar snake, that is not probably going to be a python. Why? Because the logical class formed by the 4 snakes listed before it are all venomous and pretty mess you up lethal kind of snakes. Bite, die. All right? You could presume, in terms of the category that's formed by that, that this little baby python, when I was walking up my friend's house, walking up the stairs with a box of beer last week, and his flatmate had this little snake just in the front. I was looking at him, I'm like, oh wow, there's a snake on the floor. Oh, that's right, it's only a little python. He's just pretending to be a big snake. I don't care. Kiwi, scared of snakes. Thanks. Okay, that's the first rule to note here. The second one, and again, these are syntactic presumptions. These are things that are used where there is ambiguity. Yeah. Oh, no. Okay, that's not going to help much. That's not much at all. Sorry about that. Well, now you do have all the horrible Latin phrases on the screen. Sorry. It's not going to cheer you up much. Okay. The second presumption they have, and again, this is in times of ambiguity. If you're in the list, of items, knife, blade, pocket knife, halberd, scimitar, and you're trying to determine whether the thing that you've got, well, it's kind of like a runcible spoon, or it's a letter knife, for example. There's no open-ended class here. You just got a list of 5 items, and we're trying to determine, or the judge is trying to determine, does this constitute a knife? Well, the way that we're going to determine whether this is a knife, when you've got a list of items, is by presuming that the word knife takes on the character of the words around it. Again, this is only in times of ambiguity. So if there is a particular term, we've got our letter opening knife, we're trying to determine whether that is a knife within the meaning of this section. A weapon is defined as, or a bladed weapon is defined as pocket knife, katana, bladed knife, or dagger. Is our letter opening knife considered a knife within the meaning of that? Well, the meaning of knife in that collection of words takes on the character of the other items around it, and all the other items around it are commonly thought of as weapons, things capable of inflicting harm, pain, stabby stab, cut. And so that's in that situation, again, we would be making an argument that it's not. A lot of these things you'll find, though, are questions of degree and argument. You've got to make an argument one way or the other. And that is, to be honest, I found that as a business student coming and doing law is one of the hardest things. Knowing that you can go into the court with just what you think is the best argument in the world and come out with a cost order against you. Because we can be really sure about some things and others may just disagree. And if those others are judges, it's a bad day. It's a bad day in your life. Okay. The Expressio Rule, expressly, again, this is a syntactic rule, expressly including something. I don't have an example for this. Expressly saying that something's included in the class can exclude things that are not. I haven't thought of an example for this. I had one last year and I've forgotten what it was. I'll come back to that. And the last two, though, are actually to do with statutory instruments being in conflict with each other. So it's not so much interpreting a particular statute, it's where you've got 2 statutes, and one is earlier in time and one is later in time, and they're in conflict in some way. All right. Sometimes you'll have this. Sometimes you'll have statutes, for example, the federal government has this habit of giving things like everybody is entitled to human rights, or the wildlife, all wildlife in Australia is now precious. And that's nice and all. That's a very broad statement. broad statement. Because the default rule is, of course, if Parliament has a piece of legislation and then they pass another one, and they expressly say this one now repeals this one, that is not a problem. We just follow this new one. That's easy. What's tricky, though, is when they have a piece of legislation, they pass a new one which doesn't expressly repeal the old one, and some things are now in conflict. What's some examples? Yeah, for example, all wildlife. It is now an offence to kill indigenous wildlife in Queensland. Right? That's a very broad statement. It's a very, very broad statement. And if there was a particular form of indigenous wildlife, which is a pest, there may have already been a piece of statute that says you are allowed to kill up to 10 possums if they are rampaging through your farm per day. All right, so that's a very specific statute. All right, so the key thing to note here is that by default, the one later in time is going to win. That's this the legis rule. Legis posterius priores contrarius abrogates. Or whatever, I can't pronounce it. Who am I kidding? I don't speak Latin. When the provision of the later statute, the one later in time, so yes, the one closer to now, so the more recent one, yes. By default, that will impliedly repeal the older one, all right? Unless, and this is the exception to that, is this bottom one, this Generalia rule, which says it won't, if Parliament intended to repeal very specific pieces of legislation, it really has to do so by saying it. It just says, we repeal this. So if there is this, you can kill any form of wildlife that comes onto your farm, provided you carefully do it with this, this, and this, regardless of whether it's indigenous or not. And then later on, they have this protection of indigenous wildlife. It's an offence to kill wildlife. These two are clearly in conflict, right? But arguably, this one is more specific. And what they've said in terms of statutory interpretation, whenever this comes up, and to be honest, it comes up less and less because the parliamentary drafting teams have electronic information that goes and checks these things. Oh, look, we're going to be in conflict here. But it still can come occasionally. Basically, it's not going to imply to repeal it if the earlier one has a very specific purpose and scope and role. This one will not impliedly repeal that by default. Okay, that's another thing we're doing with statutory interpretation. A little bit of time, and I'll talk about the group assignments. Okay, before I mentioned about the purpose of a statute. All right, a couple of things to note. When trying to determine the purpose of a statute, the court, when interpreting the statute, is allowed to try and determine what the purpose of the statute is by reading the statute. That seems pretty logical, and all of the things that are in it, and all of the various divisions and subdivisions. All right, but what if you can't? If you've got two parties are bringing a dispute to the courts involving a specific section, and it's ambiguous one way or the other, and we want to determine the purpose because the one which is closer in line with the purpose of the act is going to win. We still haven't worked that out. Well, what the court can do is refer to what's called extrinsic materials. Can go look elsewhere. Can go and look at things. Again, things like the speeches of the minister. What the minister said when enacting this particular act. They can go through and look at those things. But this only if it's still ambiguous after reading the whole act itself. Well, sort of. Well, what you find is that people want to win. And so as a result, something that seems completely unambiguous, very well-paid barristers will try to bring or cast some doubt in the judge's mind when arguing their case. Oh, well, Your Honour, it could possibly mean that this thing here, and if we could refer to this bit over here, they certainly mentioned that could well be that this actually was intended to be something else. And this is the nature of the beast. And this is the thing I said, I found it really hard time coming from an accounting backgrounds, doing law, where you go from having very, a lot of precision. Counting global accounting principles. They were just moving to international GAAP when I was doing accounting. So you can work out how long ago that was. But by and large, when you're reading a balance sheet, there's not a lot of wiggle room. It's this number, and this number. do your net assets, equal your other side. If yes, balances. If no, go back and fix it. Whereas your law, it is about this arguing, and this degree of argument, and that can be really hard. It's a hard thing, I think, for you guys to appreciate, because really, from your minds, you should be thinking fundamentally about the dollars when doing an analysis, and that's why I'm going to ground the PPL tasks are all ground. You guys, from a business perspective, what's the risk? What's the risk analysis that we're going to do here? How much money are we going to get? What's the likelihood we're going to succeed? How much is it going to cost us? If we fail, how much costs is it going to be? And so on. That's because these are really the tactical aspects of the law that I think is a worthwhile thing for you guys to sort of get to grips with. So anyway, so that's intrinsic materials are a mechanism the courts can use if there's still doubt when they're trying to resolve ambiguity. These slides are in a funny order, to be honest. I'd actually mentioned this earlier. These are a couple of key, just key things. I'd mentioned the fact about person. So if you see the word person in any statute, the Act's interpretation said that includes body corporate. Sometimes times are slightly modified by the Act's Interpretation Act. So if something's got to be done within that particular time, it'll actually go to the next business day. Still, it extends time to the next business day if time runs out on a non-business day. So it's the end of the current day and then to the next one. So just make note, when you're reading a statute and you have a time limit for doing things, by default, all government departments and legislative instruments follow those rules. So you've got a specific number of days to follow things. And gender. Contemporary statutes don't have genders as a rule. If it does, it says he and she. But these days, the Oxford Dictionary's changed. So the word they since 2014 is acceptable in the English language to use as a genderless singular pronoun. Do you everyone know that? There you go. Oh, there you go. I'm not going to get too much in that. Dictionaries. Dictionary makers don't make law, but they can be used to confirm a meaning where it's already plain. What does that mean? If the ordinary meaning that you're giving, and again, this seems really dumb when you've got two sides arguing about the plain meaning of a word. If court is comfortable that an ordinary word has a particular meaning, they can go to a dictionary to confirm it. You don't go to the dictionary for the definition, though, which is a hard one for, I find the first year law students have a real hard time with this, particularly when they're reading words that they're like, what does this word mean? You guys won't need to take dictionaries into your exam for this subject. This is fundamentally not how this one's going to work. Anyway, the slides are a little bit out of order because before when I mentioned the primary or dominant approach to statutory interpretation is what we call the purposive approach. Judges are obliged, if there are two sides and there are two possible interpretations and they can't work out which one, to look at the Act's purpose in order to determine which the preferable meaning of that statutory thing is. And that's the dominant approach. Why is it the dominant approach? Because the Act's Interpretation Act says so. Parliament passed a law that says this is now the way this is done. You'll also may or may not note, it's got section 15, capital A, capital A. In the Australian context, and I don't know if they do this elsewhere in the world, when they amend legislation, if they don't want to repeal a particular section, they just want to insert something, they put capital letters after it. So capital A will mean it'll come after section 15. And then capital A comes after section 15, capital A. And so what you find is that some statutes that get modified a lot, Social Security legislation, Migration Act, and Family Law Act. If you ever have to read those things, you have a lot of capital A, capital C, capital D, capital X, capital Z as a result. And you just know, you can't, it's not a code, it just means something's been modified many times. And if Parliament's wanted to put it in a specific spot. Whereas well-written contemporary legislation like the 1997 Income Tax Act is actually structured in terms of a primary section and then a dash with a subsection, with the idea of meaning that in theory you could put as many things under this as you need to. So it just reads a lot better. Okay, one last slide. I'm going to talk about the group stuff. And that is in our court system. This is quite unrelated to statutory interpretation, but it's actually a pretty important area of contemporary legal practice. It's called Alternative Dispute Resolution, or ADR. And it goes like this. Going to court sucks. It is expensive, it is risky, and it is emotionally draining. It's time-consuming. You just go on. Expense taxpayer dollars. It is win-lose. You've got one winner, one loser. Sometimes it can be just lose-lose. Both sides lose. It involves the legal profession. You should stay away from those rat bags as much as you possibly can. It is just, all in all, it's just a horrible experience to go through and do. Don't get fooled by American crime shows and legal dramas where they're all suiting up and rocking off to Harvey Specter type courts. No. It's horrible. And so for a long time, the Parliament, the government, they have a pretty vested interest in people not going to court. It costs the taxpayer a lot of money. And it's not good for party. It's very emotionally damaging. It's a horrible profession to be in. And so there are a whole bunch of systems that are in place to try and get people to avoid going to court. Now, there's sort of a continuum of formality in terms of how these structures and systems work. Because let's face it, if we got our contractual dispute, it's way better if we just sort that out amongst ourselves. It's just so much easier. We just thrash it out. Oh, this stuff you're selling was lower quality. Oh, maybe I should pay a little bit more than nothing. And we sort that out between us. That's probably fine. That is one avenue, I suppose, which is just direct negotiation with the other side. And again, what's really helpful when you're doing direct negotiation? Knowing how strong your legal argument is. Because like anything in negotiation, knowing your own hand is a very valuable tool in your arsenal when you're trying to negotiate for the best outcome. And that's why these sorts of courses can be really helpful as a result, to try and get a handle on where you're at. I'm not saying you shouldn't seek third-party independent legal advice and get them to do risk analysis as well, because they're covered under professional indemnity insurance if they stuff up too. But by and large, if you can sort it out yourself, that's great. Sort of the next step from that, though, is something which in some jurisdictions, in some situations, the courts actually make you do. Courts will actually make you. If you go to QCAT, go and do mediation first. Mediation is essentially the same thing as negotiation. We're thrashing it out, but we're doing it in front of an impartial person who's there to stop us basically from swearing, cursing, stabbing each other. Because usually when the disputes start happening, we don't like each other. That's why the whole thing about courts is adversarial. Our system is adversarial in nature. And usually the whole reason you end up in court is because things have gone pear-shaped. Things have gone bad. It's not uncommon for people who want to inflict harm on the other side. So the whole point of mediation is to try and put that in a low-key environment where you're less stressed so you can thrash out. Now, one of the other advantages of mediation is that often, particularly in things like family law, it's not strictly speaking a zero-sum game. Most of you guys have studied economics at some stage when you talk about game theory, where you've got one resource, usually just money, and we're just trying to win as much money as we possibly can from the other side. It's a fixed amount of money. It's a zero-sum game. The more money I get, the less money you get, I win, you lose. Whereas in some things in family law, sometimes actually thrashing the issues out, getting to behind what they really want. And I was just watching a video the other day with the FBI's top hostage negotiator, being able to negotiate with people. And the first thing that he tries to get them to really understand, first of all, get on the same level culturally, emotionally as the person that you're dealing with, and try to get to know what is it that they want. Because sometimes, particularly in things like family law, people just want to have a good relationship. They want to be able to get on with their lives. They want to not be crying themselves to sleep every night. It's not strictly speaking about money. And what you can find even in contractual negotiations. Justice have got a contractual negotiation, but it could just be that, look, we just don't want to fight anymore. Why don't we just settle this now and save ourselves the hassle of doing it? And so that's part of the advantage of having a mediator, is that they can help try for both sides to get a handle on that rather than just being at each other's throats. Mediators really come in two flavors. You've got the non-legally trained ones, and you can have legally trained ones too. So you can pay money, a lot more money, to get a barrister or somebody with legal training to act in that role. And so they can both act as a mediator in the conventional sense, trying to get you to thrash your ideas out. But they can also appraise your various positions legally as well. And that can be very helpful because it's better off to get an impartial person to look at both of your legal standpoints and say, look, you know that if you go to court, you're going to lose. And, they're going to win. So, you probably want to come down from this amount and go to that amount. And again, independent third-party advisors like that, they don't have a vested interest either way. That's the key thing to know. So you can do that, or you can get your legal case. Each side presents a legal case, and you post it. Just give it to a barrister. Then they write out a structured appraisal, and then give it back to the two parties. And whether or not that can be adduced to the court as evidence or not, that is for the two parties to determine ahead of time. Okay, industry-based schemes. Some industries make you go and through a whole big series of hoops in that particular industry before you go to court. So maritime things that involve that, and I'm not sure which other ones in Australia. Farming, things like that. They have their own bodies. So if you have a dispute between two parties, you go through their systems, their bodies of arbitration ahead of time before you go to the court system. We call these clauses. There's a specific, in contract law, you can have specific clauses that you can put into a contract that says this contract requires the parties to go to this arbitration in this way before they can go to court. And those are valid. And the reason is we don't want people going to court. Court sucks. The final one is arbitration. Arbitration is just like a court. It's a formal, structured system where you come in and an appointed person with appropriate training will determine your matter and give a ruling one way or the other. It's not a court, but in a lot of these systems, the courts will place great weight on what the arbiter comes to. So if the arbiter wholeheartedly endorses the views of the other side and you still want to go to court, well, good luck to you, because they'll place great weight on those things. So that's it. So these are some systems of ODR. And I only put this for one slide. I don't know why I only one slide, because it's actually a huge part of law, contemporary legal practice, is this alternate dispute resolution. It's strictly speaking, it's elective for the law students, or it had been up till last year. Now it's mandatory. So they do a first year subject in ADR, and they do an elective in the fourth year too. Okay, I'm going to leave it there for the material. I'm going to talk about your assessment. But before we do that, groups. This is the first of the PBL tasks, and so we have to allocate you guys into groups. You know what I thought about doing was to just go 1, 2, 3, 1, 2, 3, 1, 2, 3. What do you guys reckon? What do you reckon is an appropriate way to do groups? I don't know. I imagine most of you guys hate group work. Business students I found are pretty good generally at doing it. You don't love it, but you're pretty good at doing it. You would have had to have done this if you'd done for other subjects, I imagine. Yeah? No? Did you guys not for your undergrad or anything? You didn't have to do group work? A little bit? Okay. Because it was a big, I did business management first, so it's a graduate attribute. So what we might do, okay. You guys sort yourselves out however you like, right? You've got to have, what do we got? 4, 5, 5, 6, we'll say, well, perfect. This is exactly 15. Yeah, exactly 15. All right. The only rule is each group has got to have 5 people in it, and they've got to come from 2 continents and 3 countries and 4 cities. So you guys can sort that out. Each table has got to have, so you're going to have to work, there you go, this is an exercise in combinations and permutations. 2 continents, 3 countries, 4 cities. Go. Go. You've got 5 minutes. I'm going to get some water. I'm going to switch for the externals. I'm going to switch the recording off now because I'm going to give you guys your own session on this. So